and gentlemen, dear Sajjan, a very good afternoon to all of you and welcome to this webinar being organized by the Center of Excellence Alternative Dispute Resolution at the Manav Rachna University, jointly with UNCCI, which is UNCITRAL's National Coordination Committee for India. We are delighted to have support of UNCITRAL RCA, which is UNCITRAL's regional center for Asia and the Pacific. Thanks also to Live Law and Rashid for being the media partners to this event. Ladies and gentlemen, my name is Ajay Thomas, and I am the director of the Faculty of Law at Manav Rachna University, and I'm also an independent arbitrator and act as the national correspondent for India to UNCITRAL's cloud system. I will be moderating this webinar along with Ms. Advaita Sharma, who is the Secretary of UNCCI and also an advocate practicing at the Delhi High Court and the Supreme Court of India. This webinar will be the first in a series that will be hosted jointly by us, covering topics relating to the recent stellar work that is being done by UNCITRAL in the field of international trade law. Now, UNCITRAL, as most of you would be aware, stands for the United Nations Commission on International Trade Law. It is the core legal body of the United Nations system in the field of international trade law. And the aims of UNCITRAL and its objectives essentially are to further the progressive modernization and harmonization of rules of international business. So the topic for today's webinar is very interesting. Arbitration in India, the good, the bad, and the ugly. Now, ladies and gentlemen, I'm reminded sisters who practice it are extraordinarily privileged to be able to do so. Whilst these are indeed exciting and golden times for arbitration, arbitration in India has faced a lot of challenges. But I can proudly say that in the recent past, there has been many positive developments. There has been reason to be cheerful about arbitration in India. For example, most of the decisions that have been emanating from the various high courts and the Supreme Court relating to arbitration have generally been non-interventionist and overtly supportive of the process of arbitration. The recent initiatives of the government have resulted in the 2015 amendments to the Arbitration Act, which I must say has been a big game changer to arbitration in India. And now 2019 amendments, which has some very unique provisions relating to various aspects relating to the procedure of arbitration. So, ladies and gentlemen, it is in this background that I believe and sincerely hope that with the concerted efforts by the bench, the bar, the government, academia, and the business community, both international and domestic, we can all work together to develop India to be a more arbitration-friendly seat and venue for arbitrations. For today's webinar, we are privileged, I would say indeed privileged, to have a stellar cast of speakers, which includes a sitting judge of the Supreme Court of India, a very erudite Queen's Counsel who shuttles between London, Mauritius, and now Singapore, and finally one of India's leading arbitration senior counsels. Now here's a little more about our speakers. Our first speaker is Justice Indu Malhotra of the Supreme Court of India. Now interestingly, Justice Malhotra actually started off a career as a lecturer in political science, and somewhere down the line, she switched over to a career in law. All we can say is that political science's loss was indeed law's gain. Justice Malhotra has had the privilege of being only the second lady to be designated as a senior advocate by the Supreme Court of India, And most importantly, she has had the unique distinction of being the first lady advocate to have been elevated directly to the Supreme Court from the bar. She's also the author of one of India's leading commentaries on the law and practice of arbitration in India. Our next speaker is Mr. Gaurav Banerjee. Mr. Banerjee is a senior advocate practicing at the Supreme Court of India with a practice which has a great emphasis on commercial matters and in particular international arbitration. He's a former Additional Solicitor General of India, having served the position with distinction from 2009 until 2014. Mr. Banerjee is also the Vice Chairman of the UNCITRAL National Coordination Committee for India and also doubles up as a national correspondent for India to UNCITRAL's cloud system. Our last speaker, but not the very least, is a very special person, Salim Mulan, Queen's Counsel. Mr. Mulan has been in private practice as a barrister since 1998, specializing in international commercial law and in particular international arbitration. He's a past chairman of UNCITRAL, a member of the ICC International Court of Arbitration, a senior visiting lecturer in arbitration law at King's College London, and he has also had the opportunity to defend the Republic of India in investment treaty arbitrations. Now, ladies and gentlemen, before I invite the first speaker, I'm tempted to share with you a story narrated by the grand old man of arbitration in India, Mr. Fali Nariman. Mr. Fali Nariman, in a speech a few years ago, said, and I quote Mr. Nariman, now, interestingly and incidentally, Mr. Nariman is also the chairman of UNCITRAL's National Coordination Committee for India. So this is the story, ladies and gentlemen. This is the story of a master of Zen Buddhism who once invited one of his students over to his house for afternoon tea. The teacher and the student talked for a while, and then when time came for tea, the teacher poured the tea into the student's cup. Even after the cup was full, the teacher continued to pour into the student's cup, resulting in the tea overflowing from the cup and spilling onto the floor. The student was shocked at first by the teacher's act, but he slowly mustered courage and said to his teacher, "Master, you must stop pouring. The tea is overflowing from the cup." The teacher replied, "That's very observant of you, my dear boy. And the same is true with you. If you are to receive any of my teaching, you must empty out what you have in your mental cup." So, ladies and gentlemen, a lot of us, when we attend conferences and workshops and webinars such as this, we participate in these events with our respective mental cups full to the brim. I do hope that today, if you were to try and empty that mental cup, this webinar will fill your mind with refreshing new perspectives on the law and practice of arbitration in India. So on that note, I now invite Justice Indu Malhotra to speak on all that is good about arbitration in India. Justice Malhotra, over to you.
Thank you, Ajay. Thank you for the introduction, and thanks for inviting me to speak on the good of arbitration in India. As a starting point, I will start with the 2015 amendments, which were brought in October of 2015, which have made a significant change in the arbitration landscape of India. The most important amendments, I'll just touch upon them briefly. The first was that with respect to foreign-seated arbitrations, a specific provision was incorporated which would provide for interim relief if those arbitrations which were seated abroad and the party required certain interim relief, they could now move the court under the 1996 Act. And this was actually a lacuna which was filled both post the Balco judgment when they realized that there was no provision for foreign-seated arbitration. So that was the first contribution made for international commercial arbitrations. Apart from that, with respect to India-seated arbitrations, there were significant amendments made in Part 1. The first was with respect to Section 11, which is the default part of making appointments of an arbitrator, the power was vested in the Supreme Court and the High Court, Supreme Court for international, High Court for domestic. The scope of scrutiny was specifically and clearly spelled out by incorporating a specific subsection 6A, which said that at the pre-reference stage, the scope of reference is only to ascertain the existence of an arbitration agreement and no more. Section 12, with respect to appointment of arbitrators and conflict of interest, the Indian legislation incorporated two schedules which are based on the conflict of interest under the IBA guidelines. Those were given a statutory flavor and incorporated by way of these schedules, which I don't think has been done in any other jurisdiction in the world, where they are treated as soft law by way of guidance. Apart from this, Section 12, Section 17, which is the power of the Arbitral Tribunal, they were empowered to provide interim relief at par with the court. So specific provisions were incorporated and which completely changed the position. The tribunal had the teeth to pass effective orders which had to be complied with. Earlier one had to go to the court, so that was court intervention was minimized. Apart from that, a specific statutory time limit was incorporated that all proceedings which were conducted in India, domestic arbitrations between Indian parties must be completed within a period of 12 months from the date of entering upon reference. Insofar as international was concerned, they said it was not mandatory, but it would be an endeavor should be made to complete it within a period of 12 months. I think this has been one of the most salutary provisions and been very successful in the Indian context. Then another provision was incorporated, which was with respect to the regime for costs, that is, cost follows the event. A specific provision was made, which is a detailed provision. And the last thing which I want to touch upon on the 2015 amendments was that the public policy exception was statutorily given a very narrow definition, which is not so in most jurisdictions. Section 34, with respect to domestic arbitrations, that's India seated, apart from arbitrations between two Indian parties, and international commercial arbitrations, public policy exception was brought at par, and it was specifically defined to mean three things: that the public policy exception could be pressed only if the award was procured by fraud or corruption. The second was if it was contrary to the fundamental policy of India's Indian law, not merely a violation of a statute. And the third was that it must conflict with the most basic notions of morality or justice. So it was given a very narrow construction, both with respect to domestic as well as international arbitrations, which is, I think India is the only country which has defined it in its statute in this narrow manner. Apart from these legislative amendments, the second important development was the Commercial Courts Act, where commercial courts have been set up and arbitration matters are now decided by these commercial courts, and it was obviously to fast track these proceedings. Then comes the 2019 amendments. The 2019 amendments, the major focus was to move from ad hoc arbitration to institutional arbitration. That was the main object of it. Now, to give effect to that, certain legislative amendments were incorporated. One was with respect to the default power. It was now provided that instead of the courts exercising the default power, this power would now be exercised by arbitral institutions. Now, how would the court delegate this power? To operationalize this, Part 1A was incorporated in the Act, which provided for setting up an Arbitration Council of India, a statutory body, which would grade arbitral institutions, and it was for the limited purpose of exercising the default power. If the Supreme Court wanted to appoint an arbitral institution, it should have been an institution of credibility, having a pool of arbitrators, its record, compliance with timelines, statutory provisions, completing proceedings in a proper manner, etc., were the criteria for accreditation of institutions, grading of institutions. The other aspect was to promote arbitration in India, strengthen institutions, grant accreditation to arbitrators, and one other important function which was ascribed to it was that a depository would be maintained. Now, this depository was introduced in the peculiar facts of the Indian situation. In India, 90% of arbitrations were in fact being conducted on an ad hoc basis. When the matter came to the court at the enforcement stage or objections were filed, the authenticated copy of the award was sometimes not available, the record was not available, because parties would go their own way and the arbitrator would say, where should I keep your record? So this became a major problem. So it was decided that an electronic depository would be maintained by the statutory body of all awards passed in the country. So these were basically its functions. There has been a lot of misconception with respect to this body, saying that it's government dominated. It is it will act as a regulator, and I want to first dispel that misconception. This body has not been ascribed any regulatory role. It cannot de-recognize an institution. It cannot delist an arbitrator. The only purpose is to grade institutions for the purpose of appointment of arbitrators, a statutory power. It is for the purpose of promoting arbitration in India, to make recommendations for legislative amendments, and various other such objectives. There is no regulatory role which is ascribed to this statutory body. Apart from this, there is an 8th schedule which has been incorporated, which has also been the subject matter of serious criticism by international practitioners. At the outset, first let me tell you that the 8th schedule and part 1A are form part of part 1 of the Act, and part 1 of the Act pertains to domestic arbitrations. These qualifications have been indicated with respect to domestic arbitration practitioners. There is no provision which is in the form of an embargo from international arbitration practitioners to come and practice in this country or acquire these qualifications. It is not meant for them. This has in fact been clarified by the Law Minister in several public statements, and for the time being, these provisions of Part 1A and the 8th schedule have not been brought into force for the moment. In fact, the government is giving it serious consideration, given the outburst of criticism as to whether it is justified or not. But it is my belief that there has been a misconception about these amendments. Apart from this, there have also been certain legislative amendments which were more clarificatory in nature, which emerged after the amendments of 2015 were brought into force. Now, the other important legislative development which took place in the same year was that a centralized institution called the New Delhi International Arbitration Center has been set up under an act which came into force on 2nd March 2019, and the government is in the process of setting up a centralized institution like CIAP or the Hong Kong Center in India, which is called the New Delhi International Arbitration Center, which is in the process of getting operationalized. This is broadly the arbitration landscape as it stands today. And I must say with pride that not a single award for an under the 1996 Act has been refused enforcement in India. I do believe that India today matches with any other arbitration-friendly jurisdiction, and this is reflected from the World Bank's ratings. India has climbed from 161, which was in 2016, to the 63rd position in 2019 for ease of doing business in this country. These are the broad changes which have occurred in the past 5 years. And with this, I'll close my remark for the other speakers to take on.
Thank you, Justice Malhotra, for giving us a great insight into all those recent developments, a lot of which have been very, very positive in the last, I would say, 5 to 6 years. So, ladies and gentlemen, now we move on to our next speaker, Mr. Gaurav Banerjee, Senior Advocate, who's going to tell us all about what is so bad and wrong about arbitration in India. Over to you, Mr. Banerjee.
Good evening, everybody. Good afternoon. I must say that at the outset, I am privileged to be sandwiched between two superstars of arbitration, Justice Malhotra, who has found time to write a book while holding down an office, an amazing achievement. I don't think I can think of any other single judge in the Supreme Court who's done this at the same time. And then, of course, Mr. Salim Mullan, who I had the privilege of meeting for the first time when he was chairing an UNCITRAL working group. So I'm the man in the middle, as it were. But I am extremely privileged, and for this I want to, at the outset, thank the organizers, and in particular I want to thank, in my capacity as the Vice Chairman of UNCCI, I want to thank the Secretary of UNCITRAL, Anna Joubon-Brett, and also Atita Kominder, who's the head of UNCITRAL RCAP, for supporting the event. Let me begin with this confession. 10 years ago, if you had given me this topic, I would have come out with a litany of bad things about arbitration in India. But the reality of the matter is, as has been so eloquently demonstrated by Justice Malhotra, that the landscape has dramatically changed over the last decade and certainly in the last 5 years. So I must admit to having had some difficulty in isolating what I still feel to be areas of improvement. And with that caveat, may I say that I'm looking at this mainly from the point of view of a practitioner. And as a practitioner, if I could just look at 3 stages of the process where there are still bottlenecks and still room for improvement. The first part is the pre-reference, the appointment of arbitrators. Now, obviously, appointment of an arbitral tribunal is critical to the process because the entire process really depends on the consent that a party gives to having a fair and impartial arbitrator. And that, of course, is the reason for the narrow scope of interference when the award finally is pronounced. But here, the problem that we have been facing and the bottleneck that we have been facing and still not completely ironed out is this history of judicial intervention in the appointment of arbitrators in the default provision. So we've had 3 rounds. Many of you will know Konkan Railway, 3 judges, Mehul Construction, then Rani Construction, then SVP. So 7 judges finally deciding that it's judicial and not administrative. And then, of course, you had the National Insurance Boghara case, where you had those 3 categories formulated by the Supreme Court as to what and what should not be decided at the Section 11 stage. Now, as mentioned by Justice Malhotra, certainly the legislature stepped in and brought in 11(6)(a), the idea being that the scope of the Section 11 jurisdiction is very narrow, and it's only now limited to examining whether or not there's an arbitral agreement. And so presumably the bottleneck will now no longer be a bottleneck. But having said it, I do have some reservations, because what is still not clear to me is what happens to issues like arbitrability, accord and satisfaction, non-signatories, or any other issue which was earlier debated under Section 11. You go to a judge, you tell him, Judge, please look at the agreement. There is an agreement, appoint an arbitrator. Inevitably, the judicial mind will look beyond that and may think of doing justice in the case. What also concerns me is that we will now have, post 2019, a situation where you have an arbitral institution appointing in default, 11(6)(a) being deleted. So to my mind, there is still room for improvement, perhaps legislative intervention to clarify what would be the scope at the Section 11 stage, keeping in mind that we really don't have a clear answer to what is to be done with some of these thorny issues. So that is my comment on the first portion, which is the pre-reference portion of the proceedings. Now, so let's assume we've got through that bottleneck. Now we move on to the next, which is the arbitral proceedings themselves. Now, this is where in the past there were many problems. I mean, there was the problem of delay. There was the problem of expertise of arbitrators. There was the problem of bias. Many of these have been addressed, but there are still some aspects which are quote unquote bad and perhaps would require some thought as to improvement. Firstly, the delay issue. The intervention of 29A has been, not to put too fine a word on it, wonderful. It has really speeded up things. There are comments about the 2019 amendment. I don't want to go into the change which has been made, but there are some legacy arbitrations which seem to sort of peter on from year to year. I mean, we all have horror stories of 10-year arbitrations, but fortunately that problem does now seem to have been addressed, so I won't say much more about it. More serious, according to me, is the question of expertise of arbitrators, bias, gender inequality, and such matters. Yes, it is correct that we are the first country to really introduce the 5th and the 7th schedule in statute. Certainly a major improvement. There is one aspect which I think, certainly as a practitioner, seems to cause me a little concern. When one gives a declaration as an arbitrator under Section 12, apart from absence of conflict and 5th and 7th schedule issues, the potential arbitrator also has to indicate that he is not busy. He has sufficient time to devote to the arbitration. Sometimes one feels that these are more honored in the breach, and popular arbitrators are ever more popular. I do feel that particularly the bias aspect and the fact that you can only challenge 5th schedule bias right at the end is still a loophole which needs to be addressed. The unedifying prospect of sitting through a 1.5-year arbitration after having challenged an arbitrator is something which one balks at as a counsel. Incidentally, one other issue which still may require addressing is the Section 16 issue, where the respondent challenges the jurisdiction of the tribunal. Inevitably, tribunals, I mean, we all know the competence rule, which is not in that sense absolute. You have a 34 recourse, but the reality is almost all tribunals do not like their jurisdiction being challenged. And one easy way of getting out of it is to football the Section 16 application to be wrapped up with the merits. I'm not sure what the answer to this is. One possible model law answer was an appeal under 16(3), but I am not in a position to offer a solution. But this is an aspect which definitely needs addressing, perhaps by the legislature, perhaps by the judiciary, by saying these matters should be decided preliminarily, otherwise there's a problem. The other aspect which is of interest at the present moment is this increasing tension between independence of arbitrators and party autonomy. So you have a series of cases which I'm sure many of you are familiar with, starting with Perkins and going on, where the court seems to be taking the view that even perhaps in pending matters, you cannot have unilateral appointment. This is also an area which really requires some decisive intervention either by the Supreme Court or by the judiciary or by the legislature. Essentially, these finally, if I come to the final portion, which is the last but not the least, which is the enforcement. Certainly, as mentioned by Justice Malhotra, the 34(2) scope has been reduced. Patent illegality has been introduced only for purely domestic non-ICA awards, arbitrations. Yet, to me, the simple matter of deposit of money does not seem to be an answer. Perhaps there may be something like a more formal admission hearing where issues are formulated almost similar to Section 100 CPC, where at least the judge applies his or her mind at the time of admission. Because what one finds as a practitioner is the appeal gets admitted, the monies are deposited, usually by public sectors, and then the matter, because of docket pressure, is not heard within the statutory 1-year period. You cannot blame the High Court judges. They have too much on their plates. But the reality is that this is an issue which still remains to be addressed. So if I can summarize, there have been major improvements, but yet there are issues which I would consider as bad, in the sense that bad can be addressed. They are there at every stage, and it would be helpful to address them. I credit the government with introducing amendments regularly. There is no shame in that. If there is a problem, there should be debate and there should be further amendment. Thank you for your attention.
Thank you, Mr. Banerjee, for your insights into what is bad about arbitration in India. But I must personally let you know that I think you've not done a very good job of portraying the very bad things about arbitration in India. You've been too kind to all that is good about arbitration in India. Anyways, on that note, let me invite our next speaker, Mr. Salim Mulan. Mr. Salim Mulan will speak on all that is ugly about arbitration in India. Over to you, Mr. Mulan.
Thank you, Ajay. And Gaurav, you know, in a sandwich, normally the part in the middle is the best part. Right, so as you say, Ajay, it falls to me now to address you on the ugly side of arbitration in India. The task could be thought to be an ungrateful one, but in truth, every arbitral jurisdiction has an ugly side, or to put it differently, aspects of its framework for arbitration, be it in the statute, in the lex arbitri, in the arbitration statute, in its arbitration jurisprudence, or in the everyday practice of arbitration, which have gone seriously wrong and which need fixing. That would be my definition of ugly. Now, the difference between India and most other arbitral jurisdictions is that whereas practitioners in other jurisdictions will usually be keen to portray the attractive features of their jurisdiction while discreetly fixing those problems that inevitably exist, a great number of our Indian colleagues appear to take particular delight in doing exactly the opposite. So in India, it would appear the grass is always greener elsewhere, and the national sport is to say so in as vocal a fashion as possible to the outside world. Now, to some extent, I speak in jest, but there is a serious point which I would invite you perhaps to reflect on, and it's this. India, as we have just heard, has made great efforts over the years to clean up its act in the field of arbitration and get rid of many of the flaws which have prevented it from rising as a proper arbitral hub. In recent years, unlike many countries for which legislative time in this field is either sparse or non-existent, India has consistently shown a willingness to achieve progress not simply through judicial fixes to its case law and through the development of best practices and rules by practitioners, but also through legislative amendments. And that is, in principle, something that should be lauded and represented to the outside world as a positive sign, not disparaged and represented as a drawback. If India and Indian practitioners do not start actively and positively selling India as an arbitral jurisdiction, they should not expect perceptions to change, and they should certainly not expect that it's others elsewhere that will do so. So there may, of course, be a need to ensure that the legislator properly understands the requirements of the field and to ensure that the legislative intervention is judicious and well calibrated. But again, a legislator which is willing to devote parliamentary time to try and further the cause of arbitration is in principle a good and a pretty rare thing, not a bad one. Now, with those introductory words, let me now turn to the ugly, that is, to serious issues which may be in need of urgent fixing. And I will make my remarks by reference to the three areas I've highlighted in my introduction. One, the statutory framework, two, the arbitration jurisprudence, and three, the everyday practice of arbitration. Starting with the statutory framework, it's simple enough to identify the current ugly duckling. It is, of course, the Arbitration and Conciliation Amendment Act of 2019. In his inaugural address in New Delhi last February, Lord Goldsmith, and let me make that clear, I don't think anyone can doubt Lord Goldsmith's credentials as a friend and promoter of Indian arbitration for a considerable time, but he expressed the following views at this inaugural address last year, and the act then was still at the stage of a bill. He said the bill would have the effect that, I quote, foreign businesses will not be prepared to sign up to agreements providing for Indian arbitration. He predicted that it would set back the cause of Indian arbitration by many years, perhaps a generation. He said it was not a case of one step forward and two steps back, but one step forward and 10 steps back. And in case we hadn't really understood, he went on to say that having pushed the Sisyphean rock of Indian arbitration painfully step by step up the steep slope of international acceptability, we would now be releasing that boulder to plummet in free fall back down again. Now, he identified two features of the bill which he found particularly egregious, and both have been mentioned already by Ms. Justice Malhotra. First, the proposed divisions for the new body, the proposed provisions for the new body of the Arbitration Council of India were not merely to promote arbitration, as was recommended, but apparently also to regulate it. And his view about that was, I quote again, the idea that the government-appointed body should regulate arbitration and arbitrators is anathema to the idea of free and autonomous arbitration. The second feature he was criticizing particularly was the proposal for the required qualifications of arbitrators as specified in the new section 43G and in the 8th schedule of the bill, which he read as prohibiting the appointment of foreign lawyers and of non-legal experts as arbitrators in Indian-seated arbitrations, because, and I quote again, you would have to be an Indian advocate to qualify. So these were the two points he was bringing out, particularly to criticize. Let's take each of those in turn. It is a fact that care must be taken by governments when taking measures to support arbitration. They must make sure not only that they don't interfere, but that they are seen not to interfere. Perception is absolutely key. Thus, in my home jurisdiction of Mauritius, every step we have taken to promote arbitration since we passed a new International Arbitration Act back in 2008 has obeyed that cardinal rule. every involved minister and civil servant has used every public platform to reiterate that the mission of government was to support and not to interfere. The Mauritius International Arbitration Center, which is wholly owned by the Mauritian government in the same way as many other very well-known arbitration institutions around the world, is independently administered by one of the most respected international organizations in the field, and that's the PCA. And its independence is further guaranteed by express provisions in its statutes and by international agreements with the PCA. So it's really important that the Indian government take particular care to ensure that the new proposed Arbitration Council of India not interfere and be seen not to interfere with arbitrations. And in that context, there are, in my view, two broad issues that one needs to consider. First, what functions will this new body be exercising? And secondly, who will be sitting, who will be making up that new body? Let's look at both of those in turn. As to the functions of the new body, as I understand it, and as acknowledged by Lord Goldsmith, there would be promotional activities, and that, of course, is unobjectionable. There are then functions, as we heard from Ms. Justice Malhotra, of accreditation, gradation, and that of repository. Now, those, to my mind, are to be understood in the particular context of India, where ad hoc arbitration has remained the norm, making the achievement of quality and best practice very difficult indeed in a country as vast and diverse as India. A further consideration to bear in mind is the purpose of the accreditation and gradation. Again, as I understand it, the same will not have the effect of prohibiting any given institution or individual from operating, but will be merely advisory. And we heard that again from Ms. Justice Malhotra earlier this evening. The one statutory consequence, so the one thing that bites, to put it differently, will be that the possibility of being nominated as appointing authority under Section 11 of the 1996 Act will be reserved for accredited institutions. Now, that, if you think of it, is a fairly circumscribed question, especially when you bear in mind that the actual power of designation of the appointing authority will remain in the hands of a judge. So certainly something to look at and to carefully balance, but not a huge function in the grand scheme of things. As for the composition of this Arbitration Council of India, I am not sufficiently conversant with the Indian context to say whether the law as currently drafted gets the balance right between the need to ensure two things need to be balanced. One, that effective government support can be given, and two, that the body, as I was saying earlier, be perceived to be sufficiently independent from government. But it appears to me that much of the criticism which is being addressed to this question of composition of the ACI at the moment ignores altogether the first element. I can tell you, as someone who has been working firsthand with government for years to develop an arbitral jurisdiction, that it is absolutely vital to have the relevant senior government officials on board the project and to make them stakeholders in the project. Nothing can or will get done otherwise. As I say, it's a question of getting the balance right between effective support and non-interference. If it's felt that the balance as currently proposed by the legislator is not right, the solution, in my view, is for practitioners to engage with government to make sure that government understands the countervailing considerations. It is not vociferous denunciation in international fora. Now, as for the question, the second big issue which Lord Goldsmith was criticizing, which is this question of foreign lawyers acting as arbitrators, I can take that pretty shortly. Some have sought to defend Section 43G and the 8th schedule by saying that it is not meant to debar foreign lawyers. But I think the answer to that is pretty short. If a lawyer of the caliber of Lord Goldsmith, and he's certainly not alone, has read the provisions as having that effect, that is a clear sign that one ought to revisit the drafting of those provisions, all the more so, as Ms. Justice Malhotra has highlighted earlier, and I was there when the law minister at the book launch of Ms. Justice Malhotra's book a couple of months ago said it, if the intention is that it not have that effect, then they ought to be revisited. And indeed, it would appear that government has heeded the concerns expressed and that the provisions to this date are not in force. So certainly something to be concerned about, something to look at carefully, but ugly, I wouldn't go that far. Now, to conclude, therefore, on the statutory issues, there are, as everywhere, issues to be dealt with, but it seems to me that the support which government is seeking to bring to promote and institutionalize the field should be welcomed rather than decried. Where it's misguided, as will sometimes happen, the solution is to engage and discuss, not to overreact to the detriment of the perception of India and of the significant efforts that are being made. Now, let's turn to the jurisprudence. The ugly side of Indian arbitration jurisprudence, as Gaurav was saying, asked me the same question 10 years ago, and everyone knows what the answers would have been. The two thorns in the side of Indian arbitration have historically been the assumption by Indian courts of supervisory jurisdiction over foreign arbitrations and an overly expensive interpretation of the concept of public policy under Article 34 of the Model Law, Section 34 of the 96 Act, and Article 5 of the New York Convention, that's Section 48 of the 96 Act. That first issue about supervisory authority over foreign arbitrations is now well and truly dead following the Balco judgment and the 2015 amendments to the Act. That's a very significant achievement. The second issue also appears to be on the way to being resolved, but there it's fair to say that the road to resolution will be less straightforward. And there's a simple reason for that. And it's that this issue has been a thorny issue in many, many jurisdictions. Why? Because it cannot simply be settled by the recognition of the correct text. It also requires, if I may put it bluntly, a change of judicial attitudes. And that's no criticism on the judges. It's simply that it requires a meaningful understanding of the field and an ability to apply the test faithfully in a spirit which we are very accustomed to being in the field, but which a lawyer from outside the field may not find or may find counterintuitive. Why? Because it sometimes involves doing what does not come easily, I would submit, to any lawyer, and that is to resist the temptation of correcting another lawyer's perceived errors of law and to give full effect to the principle that awards cannot be reviewed on the merits, even when you intensely disagree. In terms of the test, the issue does now appear to be settled. Saw pipes is no longer good law, both through jurisprudential developments which have consistently gone back to the Renu-Sagar test and through legislative amendments in the 2015 Act, as we heard. As for application, the recent judgment of Mr. Justice Rohinton Nariman in the Vijay Karya case provides a very recent example of what does seem to be the correct approach. Now, questions have been raised as to the recent, even more recent decision of the Supreme Court in NAFED and Alimenta. Let me say a few words about that. First point to note is that the case arose under the 1961 Foreign Award Recognition and Enforcement Act, which has been superseded since by the 1996 Act. So it's not strictly speaking a case under Section 48 of the 96 Act, as amended in 2015. And that, I would submit, is something one should bear in mind when assessing its precedential value, especially as both Vijay Karya and NAFED were decided by a three-judge bench. Secondly, the facts were very stark with allegations of breach of due process. It was alleged that NAFED was deprived of legal representation, that Alimenta's arbitrator before the appeal board, Alimenta's arbitrator on the first tier of the arbitration went on to represent Alimenta before the appeal board, and that the appeal board interfered or increased interest suo motu. As we know, hard cases on the facts very seldom make good law. Now, coming to the substance of the decision, I must say I'm a bit concerned as to the approach taken and the result reached. While the correct cases were cited and the legal test probably correctly articulated, the decision starts, if you read it, with what in any view is a review on the merits of whether the impugned contract had been cancelled by operation of one of the contractual clauses by reason of the refusal of the central government to allow export of the relevant commodity. Now, that does seem to me, with the utmost respect, to be the wrong starting point. and importantly, not one which will usually be conducive to reaching the correct solution. Because as I noted a moment ago, the very difficulty in cases where public policy is invoked is to weed out true violations of fundamental public policy from disguised appeal on the merits. Now, that will usually require that the correct test be analyzed and identified, and the need for restraint identified, before the court's view can be colored by what it may see as the rights and wrongs of the merits of the case. Now, it may be that the case could have been decided on due process grounds. And I would remind you that under the New York Convention, as under the model law, due process falls under the first category under 34.1 or under Article 5.1 and not under Article 5.2. So there would have been a different basis which might have avoided falling into the pitfalls of public policy. But I would still note in that respect that phosphor, the particular commodity exchange rules that were used in that case, in fact operates exactly as happened in this case. And the same was accordingly. So what the complaints that were being made are in fact contractually agreed by both parties. Now, I recognize that may seem odd to anyone who's not conversant with English commodities arbitration, and it's maybe something we can come back on. As for the interest element, it's not clear that the increase in interest rate by the appeal board, even if effected in breach of natural justice, would have justified setting aside the whole award. So that's what I would say on Alimenta. All in all, to come back to the more general question of the public policy issue in India, a great deal of progress clearly has been made in this area of the law as well. And Alimenta is perhaps a reminder that one ought not to be complacent, and that the onus on the courts to render consistently excellent case law is a very difficult one to discharge indeed. Given the historical problems that have arisen with respect to the public policy test, it may be that particular vigilance may have to be paid to this area in coming judgments to ensure consistent application of the correct test. Because the one thing you do not want is for a narrative to develop outside India, similar to that which emerged after the Salt Pipes case, questioning the use of the public policy exception where Indian government entities are involved. Now, very briefly to conclude, let me say a quick word about the ugly side of everyday practice in Indian arbitration. Now, India, like many developing jurisdictions, has suffered from a dearth of expertise in the field of arbitration. And the introduction of best practices has been made very difficult because of the ad hoc nature of Indian arbitration. There is a crucial need to build capacity, and that, I'm afraid, will be a very long-haul effort. In that respect, it's perhaps unfortunate that the 2019 amendments, the very purpose of which appears to be to institutionalize and promote arbitration in India, and thus organize the response to both those pressing concerns, have been received with such vocal criticism. As I noted at the start of my intervention, arbitration in India would, in my view, be better served by constructive engagement between the arbitration bar and arbitration users and the powers that be. Thank you very much.
Thank you, Mr. Mulan, for giving us an insight into the ugly and the not so ugly bits about arbitration in India. And now, before we proceed to the last leg of this webinar, which is the question and answer session, I would like to ask Justice Malhotra whether she might have any responses to the good and the ugly which have been listed out by Mr. Banerjee and Mr. Mulan.
Yes. I'll first address the concerns which were expressed by Mr. Gaurav Banerjee. The first issue he raised was with respect to pre-reference intervention by the court on issues of arbitrability, accord and satisfaction. I think these issues by the amendment of 2015, which has confined the scope only to the existence of the arbitration agreement and no further, and the judicial interpretation of this provision, wherein accord and satisfaction, all these issues are to go into the bucket of the tribunal under the competence principle and not to be decided by the court. So I think legislative amendments and judicial dicta have substantially clarified this position. The second aspect, which he had pointed out, was with respect to Section 12, challenge of the arbitrator at the post-award stage. Now, this provision, we did not accept the model law or the English law, which provides an intervention, one court appeal at that stage. It was actually done with the object of minimizing judicial intervention with the arbitral process. And since the arbitrations would get concluded within a period now of 12 months to 18 months at best, the issue would be decided at that stage rather than invite court intervention during the midst of the proceedings. That was the legislative intention. But of course, these matters are for legislative change rather than judicial interpretation. The law as it stands today is that in the midst of the proceedings, you can't invoke the court. It can be done only after the final award is passed. The third aspect which he has raised is with respect to threshold issues of jurisdiction, which are raised under Section 16, he has rightly pointed out, and that is not peculiar to India alone, but I find this true of most tribunals, that they like the issues to be decided right at the final stage. If they don't normally decide it at a preliminary stage of the proceedings, so it is more a practice issue rather than something which is problematic either with the law or with the judicial interpretations for a practice of arbitration practitioners. Some of the issues which have been raised by Mr. Salim Mullan, I'll address those. The main thrust of the 2019 amendment was institutionalizing arbitration to move from ad hoc, because ad hoc had resulted in enormous delays and very costly arbitration, which went on for several years. So to rectify that practice in India, the 2019 amendments were brought about to address the peculiar situation of arbitration as it developed in India. With respect to the Arbitration Council of India, I think the constitution is not dominated by government representatives. There are 6 members. It is presided by either a retired Supreme Court or a High Court judge, an eminent practitioner, and third is an eminent academician who has specialized knowledge in arbitration. A 4th person is a representative from industry, a major stakeholder, and there are 2 representatives, one from the Ministry of Finance, Department of Economic Affairs, since it's being funded by the government, and the second is from Ministry of Law and Justice. So there are only 2 representatives on the Arbitration Council from the government side to ensure the body smoothly functions once it is set up. Insofar as the 8th schedule is concerned, that has not been brought into force, nor has the amendments to Section 11, since it is obvious that the government is giving it a serious consideration, given the uproar and the criticism which was brought about by various practitioners. But I do want to assuage their feelings, to tell them with great clarity that the law as it stands today is governed by the judgment of the Supreme Court in A.K. Balaji, that all arbitration practitioners can come to this country on a fly-in, fly-out basis. There is no embargo, there is no requirement for a foreign arbitration practitioner to come and acquire these qualifications, and in any event, they have not been brought into force. The role of the Arbitration Council is recommendatory in nature, not regulatory, and that would be very evident on a reading of the objects of this body. Lastly, with respect to the NAFED judgment versus Alimenta, it was not under the 1996 Act. It was under the Foreign Awards Act of 1961, where public policy was defined in very wide terms, and it was not, as now it's defined by the amendment of 2015, to be very specific and a narrow construction. Those are my responses to both the previous speakers.
Thank you, Justice Malhotra. We now quickly proceed to the question and answer session, which I think is something which is very well awaited by all our attendees who are actually only in listen-in mode. So now, can I ask my co-moderator, Ms. Advaita Sharma, to take over this next leg of this webinar? Over to you, Advaita.
Thank you, Ajay. Before we move on, I would like to thank once again to our panelists for the very interesting and informative session. And without further ado, would like to proceed with our first question, addressed to Mr. Gaurav Banerjee. Sir, the question is, one of the bads about arbitration in India is that the Indian arbitration law does not expressly recognize the award of an emergency arbitrator, nor the concept of emergency arbitrator. The Law Commission of India in 246 report had recommended an amendment to the definition of an arbitral tribunal under section 2(1)(b) to include emergency arbitrator. However, this recommendation did not find its way into the 2015 and 2019 amendments to the Act. Your views, sir?
Well, I can't say anything about the amendment not having been accepted. I mean, that would have solved the problem. But I don't think this is that much of a problem because if I'm not mistaken, there is a there's a Bombay High Court judgment in Arbitral and HSBC. And HSBC had got an emergency award under CAC against Arbitral. And the Bombay High Court then held that that could be enforced in a sense under section 9, and the definition of award is also quite wide. I know that there is a sort of contrary view by the Delhi High Court in, I think it was Raffles Design versus Educom. But if you read Justice Bakru's judgment there, though he seems at one point to say that you can't enforce an award because there's no equivalent to 17(2), Article 17(2) in Part 2. Yet he says that the petition is maintainable under section 9. You can give relief, but he uses the word independently. But I mean, ideally, yes, there should have been an amendment. That was what was recommended. But I still feel that you can, even today as the law stands, enforce an emergency award through the section 9.
Right. Thank you, sir. Our next question is also addressed to Mr. Banerjee. It's with respect to enforcement of awards. It's from Advocate Sahil Kotra. With timelines introduced on completion of proceedings, there appears to be somewhat greater discipline amongst arbitral tribunal in concluding arbitrations expeditiously. However, there are still concerns about the time taken for enforcing arbitral awards in India. What steps can be taken to ensure that the enforcement or the challenge proceedings in court are also disposed of within an indicative time frame?
So there is a guideline under 34(6) for domestic awards of 1 year, and though there is no such guideline in the in Part 2, but the reality is I accept that there are legacy cases like, say, NAFED, which was an award of 1989, or a Centro Trade, which was an award of I believe 2001. But the reality is the Supreme Court and certainly the Delhi High Court and certainly the Supreme Court are cognizant of this problem, particularly with regard to foreign awards. If you see the Vijay Karya Prismian judgment, which was mentioned by Mr. Mulan, I mean, it moved quite quickly. There was a judgment of the Bombay High Court enforcing it in 2019. There was a quick judgment and a very detailed judgment by Justice Nariman in 2020. Ultimately, it's the courts who are now, have woken up to the fact that enforcement of foreign awards is to be fast-tracked, and they're doing it. I mean, more than that, you can't really give the courts a guideline. I mean, 1 year is a nice concept, but I mean, they are doing the best they can. There was a suggestion by Mr. Nariman, Mr. Fali Nariman, that foreign award enforcement should only be before Supreme Court. I think that would be a bit too much. You look at the Delhi High Court and Glencore, Extrata, Tata, Docomo, any of the Delhi High Court judgments of enforcement, they've done quite a quick job where foreign awards are concerned.
Right. Thank you, sir. Justice Malhotra, may I please invite your views on this topic?
On enforcement of awards? Well,
Yes.
I have actually been advocating it, that we need specialized benches to fast track them, because the fallout is that if they are not fast tracked, it leads to investment treaty claims, which leads to a bigger problem. So the courts have been taking care of it. In fact, there was a matter which came to us it was an ICC award with about 15 volumes. And we asked the council, how long will it take? And they said it will take about 3 weeks. So we said, we are not going to give you so much time. You provide us with the convenience compilation. We went through it. And I think it was within a maximum of 3 working days that the entire issue was resolved in the Supreme Court. So we are cognizant of it, and we are making our best effort to try and fast track these proceedings so that they are concluded quickly.
Right. Thank you, ma'am. Our next question is addressed to Mr. Salim Mulan. Can you please throw some light on how COVID-19 crisis is reshaping alternate dispute resolution in India specifically, or for the panel as well?
Say again, Rachna, could you repeat the question?
Yes, sir. Yes, sir. Some light on how COVID-19 crisis is reshaping the alternative dispute resolution in India, specifically in India.
Yes, I'm not sure I'm the best place to answer specifically in India. I mean, maybe that would be best addressed to Gaurav.
Well, I mean, it's definitely pushed people, arbitrators, lawyers, etc., into technology which they were not comfortable with. So you are now having hearings on video conference, I mean, that's the future, and one has to get used to it.
So you feel that's the new normal?
Sorry?
You feel that's the new normal now?
Well,
Virtual
that's what we are doing now. That's the reality. I mean, the longer it goes on, you will have to find out alternative methods of alternative dispute resolution.
Right, sir.
And maybe if you could have Mr. Mulan's perspectives on how COVID-19 is reshaping arbitration internationally. So we all know you're extremely busy arbitration counsel and also citizen arbitrator. What are the changes that you have seen in the practice of arbitration, especially international arbitration, over the past month or so?
Yeah, I think everyone is cognizant of what is going on and of the way it's affecting. Where I'm less prone or quick to draw conclusions from what is happening now. So far as I'm concerned, most cases I'm involved in are more in crisis management mode than in any sort of groundbreaking new method of operation. Hearings that need to proceed are proceeding pretty much in the way in which we're now proceeding. Others that are less urgent and perhaps more complex, parties are taking the position that they would rather try and see how the situation develops. Now, the big question, and the one you ask, is whether it's going to create a new normal. And frankly, no one knows. Sorry to put it that way, but there are much more important questions than simply arbitration that are affected by that wider question. Nobody knows how this virus is going to leave us all over the next 18 months, 2 years, 3 years, 4 years. Now, if it helps those of us who have for years been saying, you know, I don't really need to travel all the way from Singapore to wherever, I don't give any particular case away, to deliberate, we can do that over video conference. And you find arbitrators who are very resistant to that idea. I think it will be much easier because once you've done it and you've been forced to do it, it becomes easier to convince people. And we all become more aware, obviously, of the cost of traveling or what it's doing for the planet, it's certainly a period of reflection. And I would hope it will have an impact and allow one to proceed more efficiently and in a greener way, unless it's absolutely essential to me.
So there's another question which has come from Anchal Sharma, and her question is the pool of arbitrators in India is extremely limited. So if and they also, the pool lacks diversity. So what measures can be taken by institutions or at the level of the government or even the judiciary to widen this narrow pool of arbitrators in India? It's to the panel. Any one of you can actually answer.
I'm happy to have a go if you wish, Ajay. The question is not unique to India. The question arises in most jurisdictions, certainly in terms of gender diversity, and it arises in all developing jurisdictions. And it's not just a question which is internal, say, to India or to Mauritius or to any African jurisdiction or to most Asian jurisdictions. It's also a question which affects the development of international arbitration globally, because it is becoming an increasing problem of legitimacy that in disputes that involve our states, our commercial actors, we end up always arbitrating before the same people in Zurich or Geneva or London. So it is a big question, and the answer to the global question lies in action in every developing jurisdiction. So what we have been doing in Mauritius, and what I understand the aim will be also through the ACI and through all the activities that are going to take place, are already taking place, is that the talent be created at this stage. I'm sorry, of course, my phone is going off for a reason. Okay. That the talent pool be developed by capacity building exercises, drawing on UNCITRAL, drawing on the PCA, drawing on all the actors, so that the new generation will be, first, when they're younger, good counsel, then good tribunal secretaries, and then good arbitrators as well. Unfortunately, it will take time. But I think everyone, first of all, everyone is now conscious of it. Two, the efforts are being put in, and they are being put in jurisdiction after jurisdiction after jurisdiction. So I'm quite hopeful that in 20 years' time, say, we will get to a stage where hopefully that question will not be as stark as it is. Bearing in mind on gender diversity, that while we're pushing for more representations from everyone from our part of the world, we should not forget gender diversity. We don't want to be in 20 years' time with a problem that can be dealt with at exactly the same time as we're dealing with the gender problem.
Thank you, sir. I see many questions on the screen, but unfortunately, we are having shortage of time. So on that note, we would have to conclude our session, and with a small thank you note. On behalf of UNCCI, I would like to take this opportunity to thank our distinguished panel, Justice Indu Malhotra, Mr. Salim Malan, and Mr. Gaurav Banerjee, for taking out time to share with us in-depth understanding on the subject. I would also like to thank our moderator for today, Mr. Ajay Thomas, for his efforts and tremendous support for the webinar. I would further thank UNCITRAL, that is the United Nations Conference on International Trade Law, and the UNCITRAL Regional Center for Asia and Pacific for their support. Would like to further thank our co-organizer, Center of Excellence on Alternate Dispute Resolution, CADR, at Faculty of Law, Manav Rachna University, our media partner, Live Law. Last but not the least, our attendees for their enthusiasm and participation. Apologies for the many questions that would not be addressed due to paucity of time. Do join us for the next webinar, details of which will be available soon. On that note, stay home, stay safe, have a great day.
Thank you.